43 million Americans just found out their gun permits might be completely worthless, and most of them have no idea it happened. The Supreme Court handed down a decision that's systematically taking apart permit systems across the entire country. Within months, 29 states threw out their permit requirements entirely. No transition period. No refunds. A Texas resident who paid $40 for a 5-year permit, that requirement vanished. A California applicant who spent $800 and waited 8 months, all that effort for nothing. New York City residents who went through police interviews and notarized documents are watching the entire system they complied with get declared unconstitutional. If you own a gun or care about constitutional rights, hit that subscribe button right now, because what's coming next will shock you. The constitutional wave nobody saw coming when the Supreme Court handed down New York State Rifle and Pistol Association versus Bryan. They didn't just strike down one state's law. They created a legal framework that's now being used to challenge virtually every gun regulation in America. Justice Clarence Thomas wrote an opinion that changed the rules permanently. The court created one simple test. Did this type of regulation exist in the 1700s? If the answer is no, the law fails. No balancing test. No looking at modern situations. Just history. But here's what nobody's talking about. Within 24 hours of the ruling, lawyers filed lawsuits in California, New Jersey, Massachusetts, Maryland, Hawaii, and Rhode Island asking for immediate changes. State attorneys general sent out emergency instructions. Processing offices that operated the same way for generations suddenly had to rewrite every procedure. Lower courts had no choice but to follow immediately. The justices made it crystal clear that the era of government control over who carries firearms in public was over. What happened next was a complete change in how half the country handles gun rights. And the changes are still happening. 43 million permit holders in legal limbo. Roughly 43 million Americans currently hold concealed carry permits. That number represents years of applications, thousands of dollars in fees, hundreds of thousands of training hours, and months of waiting. These people followed every rule, paid every fee, and met every requirement. Now, those permits might be worthless because the Supreme Court declared the entire system unconstitutional. A Texas resident who paid $40 for a 5-year license just saw that requirement potentially go away. A California resident who spent $300 waited 8 months and provided character references might have done all that for nothing. New York City residents who went through police interviews notarized documents, and proper cause statements could have their permits thrown out simply because permits themselves are now considered unconstitutional. But there's a deeper issue nobody's talking about. Reciprocity. Right now, permit holders can carry in states that recognize their home state's permits through agreements. If permits no longer exist, what happens to carrying across state lines? Does constitutional carry become automatic nationwide? Can someone from Texas carry in California without any paperwork? Can a Florida resident walk around New York City armed with no permit? Can states arrest out-of-state residents for carrying without local permits when permits don't exist anymore? The Supreme Court's ruling dealt with permits, but the effects on 43 million holders have created a legal mess that's playing out in courtrooms right now. The billion-dollar financial crisis about to hit. American gun owners have paid over $1.2 billion in permit fees over the past decade. That's not counting renewal fees, training costs, fingerprinting charges, or time lost waiting for approvals. Some states charge $20 for permits. Others charge $500 or more. California's system can cost applicants upward of $800 when you add up all requirements. The money from permit systems created an entire industry. Training facilities made money from required courses. Fingerprinting services handled thousands of applications monthly. Government offices hired staff whose entire jobs were just managing permit paperwork. That whole system is now legally questionable. But here's the real problem that has state lawyers panicking. Several states already face class action lawsuits asking for full refunds for permit fees paid within the past few years. If courts rule that permits were unconstitutional all along, those fees were collected illegally. New York alone collected about $340 million in permit fees over 5 years. California collected even more. The potential money states might owe runs into billions of dollars, and that's before adding damages for violating constitutional rights. Think about what that means. If you paid $300 for a permit 3 years ago, and a court says that system violated your rights, you might get a full refund plus extra money for damages. Multiply that by millions of permit holders across multiple states, and you're looking at the largest Second Amendment money situation in American history. States are worried about these lawsuits and already trying to settle cases before they go to trial. The training mandate problem. 26 states currently require training before giving out permits. Requirements range from 4 to 16 hours. About 3.2 million Americans complete these courses every year, is less than #0. One hash is greater than paying between $75 and $500. That's hundreds of millions of dollars going through the training industry every year. The Supreme Court's ruling could throw out every single training requirement in the country. Constitutional rights don't need competency tests. You don't pass a First Amendment test before speaking publicly. You don't take a Fourth Amendment course before expecting privacy. The government can't make you take voter education before you cast a ballot. If the Second Amendment gets the same treatment, training requirements fail the constitutional test. But here's where this gets really interesting and splits the gun community right down the middle. Surveys show about 67% of gun owners think training is important even when not legally required. Many people support voluntary training while opposing government requirements. The gap between what the Constitution says and what people think is practical has created major disagreement in gun rights groups. Getting rid of training requirements might be constitutionally correct, but it raises questions gun owners themselves can't agree on. Should someone carry a loaded firearm in public without ever firing it? Without understanding self-defense laws? Gun rights supporters argue freedom comes with personal responsibility. Critics say that removing requirements could put unprepared people carrying loaded weapons in crowded places with zero instruction. The Supreme Court forced this conversation, and the gun community hasn't figured it out yet. The sensitive places fight that's coming. Places fight that's coming. Even with permits possibly going away, the Supreme Court said that certain locations can still ban firearms as sensitive places, but nobody agrees on what counts as sensitive. And the fight over this question is about to go through every state. The original historical examples were chorus's, government buildings, and polling places. Modern versions expanded a lot. Post offices, parks, public transportation, stadiums, hospitals, college campuses, bars, churches, and streets near schools. New York responded to Bryan by saying, "Almost all of Manhattan is a sensitive place." California expanded its list to include any private property unless specifically posted otherwise. Exactly the kind of blanket ban the Supreme Court rejected. Gun rights groups immediately filed lawsuits. Federal courts gave conflicting answers. The Supreme Court stepped in, threw out decisions, and sent cases back down. But here's what legal experts are watching. The Supreme Court's language suggests they're moving toward extremely narrow definitions of sensitive places. If this continues, sensitive places might go back to what they were, historically. Arcard, prisons, and government chambers. Everything else becomes allowed. That means parks, subways, stadiums, hospitals, and schools could all be open to concealed carry. Or states might find new ways to ban them, leading to another round of lawsuits. The battle lines are being drawn right now. The prohibited persons problem. Nobody's fixing the prohibited persons problem. Nobody's fixing federal law bans certain people from having firearms. Convicted felons, domestic violence offenders, drug users, people ruled mentally ill, illegal immigrants, dishonorably discharged veterans, and those under restraining orders. That's about 16 million Americans. Permit systems let states catch these people before they carried in public. Background checks during the permit process stopped prohibited people before they could legally carry. If permits go away, how do states check if someone is banned before they carry? They can't, at least not ahead of time. Constitutional carry states already deal with this. They rely on background checks when buying guns and catching people after the fact if they're carrying illegally. Critics say this system only works after someone is already breaking the law. Supporters say constitutional rights don't need advanced checking, but there's a legal problem developing. If someone who's banned carries a firearm, are they breaking the carry law or the possession law? This matters for charging and punishment. Some states treat illegal carry as a minor crime, but illegal possession as a major crime. If permits are unconstitutional, can states still have separate carry laws? Prosecutors are already confused about what charges to file, and defense lawyers are using the confusion to get cases thrown out. The 21 states still standing. The 21 states still standing. And what comes next? And what comes next? 29 states have constitutional carry. Alabama, Alaska, Arizona, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maine, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, Vermont, West Virginia, and Wyoming. That's 157.6 million Americans, nearly half the country, living under permitless carry. But 21 states still have restrictive permit systems. The question everyone's asking, are those 21 states next? Gun rights groups are already filing lawsuits using the Bryan framework to challenge every restrictive permit system still operating. More than 2,000 legal challenges citing Bryan have flooded federal courts, double the number filed after the Heller decision. Some judges are striking down regulations. Others are finding creative ways to keep them. The legal situation is complete chaos. But here's what should matter to everyone. The Bryan framework isn't just being used to challenge permits, assault weapon bans, magazine limits, red flag laws, age restrictions, waiting periods. All of them are now being challenged. Federal judges are looking at 1,700 musket laws to decide if modern gun laws are constitutional. Gun rights supporters are using it to take down every gun regulation they can find. Conclusion. The Supreme Court's Bryan decision triggered a constitutional earthquake, still sending shockwaves across America. 43 million permit holders are in legal limbo. Billion-dollar refund lawsuits are piling up. Training requirements are falling. The sensitive places fight is just starting, and 21 states are watching their permit systems get challenged right now. Do you live in one of the 29 constitutional carry states, or are you stuck in one of the 21 still fighting to keep permits? Drop a comment below and tell us how this decision has affected your ability to carry. Hit that subscribe button and turn on notifications because this story is changing every single day. The next Supreme Court decision could eliminate permits nationwide or create new boundaries that change everything again. The biggest Second Amendment shift in over a century is happening right now. Subscribe now and don't miss what happens next.